Welcome to video 2, Proximate Cause. In this video, we will be introduced to the Restatement Third of Torts, Section 34, the rule of law under the Restatement Third of Torts regarding proximate cause and intervening factors. Up to this point, what we've studied has been pretty straightforward, right? Under the Restatement Third of Torts 29, we ask a single question. That question is the harm that occurred the realization of the risk that made the defendant's conduct negligent? However, what we learned in law school is that very rarely does life follow neat little silos of law, right? Usually, or at least often, something else happens between the defendant's actions and the plaintiff's injury. For instance, maybe a third party acts, or maybe a victim or plaintiff reacts, right? Maybe there's a criminal intervention. Usually, or often, once the defendant acts, there's enough time for another act to take place before we have the actualization of the plaintiff's injury. So here's a question. When another act intervenes between the defendant's negligence and the plaintiff's injury, does the intervening act, that's the act that happens after the defendant acts, does that intervening act cut off the defendant's liability? Well, that is the function of Restatement Third of Torts, Section 24. What does it say? It says, when a force of nature or an independent act is also a factual cause of harm, an actor's liability is limited to those harms that result from the risk that made the actor's conduct tortious. So think about it. There's not a lot that changes with the Restatement 34 section and the Restatement 29 section. And the Restatement 34 section, it includes when a force of nature or an independent act is also a factual cause, right? So now we have more than one factual cause. The actor's liability is limited to those harms that result from the risk that made the actor's conduct tortious. So if the intervening act simply brings about the danger that the defendant's conduct created, then liability continues because nothing new is added, right? Nothing new is added. If the intervening act simply brings about the danger that the defendant's conduct created, liability continues. The intervening event has not changed the nature of the risk. It has merely realized the risk that was already foreseen. However, if the intervening act introduces a new and different type of harm, one that was not part of the risk created by the defendant's conduct, then and only then does the scope of liability end, which means proximate cause ends, which means the defendant does not bear the liability. Okay? Slow it down and let's focus on what's really being asked. The question is always whether the harm that occurred is still the realization of the risk that made the defendant's conduct negligent. If the harm that occurred is the realization of the risk that made the defendant's conduct negligent. Liability continues. We've established proximate cause. If the harm that occurred is not just the realization of the risk that made the defendant's conduct negligent, but instead some new or different category of harm, then and only then does liability stop, which means proximate cause is not established. Got it? Here's an illustration. Suppose a construction company negligently fails to place proper barricades around a road construction site. Because the site is not protected by barriers, workers are exposed to traffic. Now, imagine that a driver suddenly loses control of their car, crashes into the construction area, striking and injuring one of the workers. The driver's loss of control is an intervening act. You see, it occurs after the defendant's negligence. What was the defendant's negligence? The failure to place proper barricades. But the driver who lost control, while their act of losing control occurred after the defendant's negligent act, it still happened before the plaintiff's injury. Yeah? And so now the question is whether that intervening act cuts off the defendant's liability or not. Under 34, the answer depends on the risk created by the original negligence, right? It all starts from the risk created by the original negligence. What was the act that created the original negligence? Failing to barricade a construction site, which creates a clear danger. What's the risk? Vehicles may enter the work zone. What's the problem? Vehicles entering the work zone may injure workers. The driver's loss of control does not introduce a new danger. It simply produces the very harm that made the defendant's conduct negligent in the first place, which was what? A vehicle entering the work site and injuring a worker. See how it works? Yeah, I want to take a second. But that's how intervening factors work. When an intervening act appears in a causal sequence, the analysis proceeds not in 3 steps, like the 29 algorithm, it proceeds in 4 steps. What are the steps? Step 1 of 29 and 34 are the same. What's step 1? Identify the original negligent risk. How do I do that? I ask a simple question. What danger made the conduct negligent in the first place? What's the risk involved? Well, here's an example. Vehicles entering the construction site, right? Now, the criminal assault, that's a different, right? I'm just giving you some examples. I'm just giving you examples so that you know where it is your mind should wind up. So if your mind takes you to a different place, you'll recognize, no, this isn't where I'm supposed to be, right? So step 1, just like in 29, step 1 in 34 is what danger made the conduct negligent? What was the risk? And I identify them. Then I go to step 2. This is what's different. If I'm doing an intervening evaluation of proximate cause, step 2 now becomes identify the intervening act. In my scenario with the construction site, what's the intervening act? The intervening act was the driver losing control of the car, right? Go to step number 3, which is step number 2 in the 29 algorithm. Step number 3 is what? Identify the harm that occurred. What is the harm that occurred? Bodily injury. from being injured by a motor vehicle. And step number 4, compare the risk. Here's the controlling question. Did the intervening act produce the very harm that made the defendant's conduct negligent in the first place? If the answer is yes, liability continues. If the answer is no, liability stops. Got it? All right. The key insight, right? The one thing that you want to remember is what? Is an intervening act cuts off liability only when it introduces a new and different risk. If the intervening act simply realizes the original risk, then liability is going to continue. Get it? Fantastic. Let's go to the Darian case, Darian versus Felix Contracting Corporation 51. What's going on in that case? Here's a quick overview. Darian is a foundational proximate cause decision, right? Because we're talking about foreseeability and intervening acts. The New York Court of Appeals held that where a defendant's negligence creates a risk or increases the risk of a particular type of harm, and that harm occurs, right? Liability is not cut off merely because of an intervening act. So please, as you are reading and evaluating your hypotheticals, you are reading for facts, and you notice in your hypothetical that there's an intervening act. There is an act that occurs after the defendant's act, but before the plaintiff's injury. Don't stop your analysis there thinking, because I have a third-party action now being introduced, the liability on the original defendant stops. That is not the case. That is a wrong assumption. You have the steps. Walk through the steps. Want to see the steps? Let's apply the steps. Before we apply the steps, let's look at the facts. I divided the facts into several different categories just in case you weren't assigned this case. I assigned or organized the facts this way so that you would at least have some working understanding of what the Darian case is. But the Darian case is really the hypothetical that I posed at the beginning of this section. You'll recognize it. Here we go. It's a construction project. The Felix Contracting Corporation was performing road construction, okay, on a busy road in Brooklyn. The company had excavated part of the roadway to install water mains. Because the excavation was near moving traffic, the site required protective barriers to shield workers from the vehicles. Here's the worksite condition. The contractor placed wooden planks and minimal barricades around the evacuation. The excavation. They should have evacuated. The contractor placed wooden planks and minimum barricades around the excavation. Now, evidence suggested that the barricades were inadequate or improperly positioned. The work area, unfortunately, remained exposed to the passing traffic. That's a problem, right? That's a problem. The worker, that's the plaintiff, Darian, was a construction laborer working inside the excavation area. He was performing tasks related to the pipe installation when the accident occurred. The driver, named Millet, was traveling along the roadway near the construction site. Millet suffered an epileptic seizure while driving. As a result of the seizure, Malay lost control of his vehicle. Malay's car left the roadway, crashed through the inadequate barricades, and Malay's vehicle thereby entered the construction site. Malay's car struck Darian, who was working in the excavation. What's the injury? Darian suffered severe injuries, including burns from hot liquid enamel, and the injuries were so severe they were classified as catastrophic. What's the issue? Here's your 3-point issue statement. Under the principles of proximate cause, that's our rule of law, here's the legal question that needs to be answered. Does a driver's loss of control due to an epileptic seizure constitute a superseding cause that relieves a road contractor of liability? What am I really asking, right? That does section could be even simpler. What's the does? What's the legal question? Does a driver's loss of control due to an epileptic seizure break the causal link between the defendant's negligence, right? Because that's what I'm asking, right? When the defendant failed to adequately safeguard the construction site. So if I had an elevator speech, I'm in the elevator. My supervising attorney who assigned me this case is in the elevator, says, hey, what are you working on? I'm working on the Darian case. What is that case? It is a negligence case. The issue's on proximate cause. Oh, well, tell me about the proximate cause issue. We have the workers at the excavation site who are responsible, who have a duty, right, to put up the necessary barricades so that the workers are protected, breached that duty. And the breach of that duty, they left a scenario which someone breached the minimal barricade and caused damage to a worker as they were driving through. Is Felix Contracting liable? Or did the intervener, the person who drove through the barricade, break the causal chain? Well, how are you going to solve that? I'm going to apply the algorithm that is provided in the third restatement of torts, section 34. Great. What's the algorithm? Algorithm begins with step 1. Identify the original negligent risk. What risk made the defendant's conduct negligent in the first place? Failure to barricade the roadside work site. Got it. What risk do I anticipate? If I don't barricade the roadside properly, then there's a real possibility that I've got vehicles are going to breach and enter the work zone, causing construction workers to be struck by traffic. Great. What's step 2? Step 2 is I have to identify the intervening act. What's the intervening act? Right? What event or actor intervened between the defendant's negligence and the plaintiff's injury? That was the driver, Malay, who breached the barricade when he lost control of his car. Was question 3, what harm actually occurred? Bodily injury to the worker who was hit by Malay's out of control car. Step number 4, align the risk. Ask the controlling question. Did the intervening act produce the very harm that made the defendant's conduct negligent in the first place? Yes. What was the harm? A vehicle entering the work zone, injuring a worker. That is exactly the risk that was created when the defendant failed to provide or set up adequate barricades. What does that mean as far as proximate cause? That means that liability continues. The intervening act does not cut off liability. That's step 1 through step 4. Got it? Let's go through the Hines v. Garrett case while we're hot. These are intervening factors that we are evaluating to determine whether or not proximate cause ends or proximate cause continues. What's going on in Hines? Here's the facts. The passenger in the train. The plaintiff, Miss Garrett, was a young female passenger traveling by train. Miss Garrett purchased a ticket entitling her to get off the train at a stop near her home. We're in a rural area, and passengers relied on the train to stop at the correct location so that they could get safely home. That's why we had multiple stops. What happened? The railroad was negligent. The train failed to stop at Miss Garrett's designated station. The railroad employee conductor carried Miss Garrett past her intended stop. After realizing their mistake, the train personnel did not return her to her stop. Oh, well, what happened? Instead of returning Miss Garrett to the stop that she was supposed to get off at the error of the train person, the train stopped at another location and required Miss Garrett to leave the train. The location where Miss Garrett was required to leave the train was isolated, unfamiliar, it was dark, and it was late at night. Miss Garrett starts to walk home because the train had passed her intended stop. Before she could reach home, she was forced to take a track that forced her to travel through some deserted areas. Long story short, Miss Garrett was assaulted by 2 men. She suffered serious injuries, and both physical and emotional. Miss Garrett sues the railroad. Here's the question. Is the railroad liable? Is the railroad liable? Number 1, are they negligent? Yes. They failed to stop to allow Miss Garrett to disembark where she was intended to, which was near her home. So the railroad was negligent. Did they have a duty? They did. Did they breach the duty? They did. Okay. Are they the actual cause? They are. We know all of that because we're asking about proximate cause. Great. How do I determine whether or not the railroad is the proximate cause or is not the proximate cause? Well, because we have intervening factors, that's an act that occurs after the defendant's negligence, but before the plaintiff's harm. What do we have going on? Step 1, identify the original negligent act, right? What's the question? The question is, what made the defendant's conduct negligent in the first place? Well, putting the passenger off in an unsafe space, right? I mean, surely they were negligent when they missed her stop, but that could have been resolved, right? That could have been very easily resolved with them turning the train around or providing other alternate safe means for Miss Garrett to get home. So the problem became when the train employee put Miss Garrett off at an unsafe, isolated place. That's the problem. What's the risk associated with putting her off at night, late, in an unfamiliar, dark place? Well, the risk is that she's going to be attacked or assaulted or both, right? Number two, what's number two? Identify the intervening act. What's the intervening act? The criminal assault by third parties. Move to step three. What's number three? Identify the harm. The harm was bodily injury. Number four is the harm that was suffered aligned with the risk from the original negligent behavior? Yes, right? The assault is the very danger that makes forcing a passenger off a train in an isolated, unsafe, unfamiliar location with the only means of getting home is walking. That is the danger, right? So what's the result? The result is that liability continues. The criminal act does not break the causal link, so it does not cut off liability. So I've established proximate cause. That is the Hines case. That is the end of video 2. So as a quick recap, what have we done? Video 1 is the introduction and application of the third Restatement of Torts, Section 29. That is the 3-step algorithm for proximate cause. Video 2 is the introduction and application of Restatement Third of Torts, Section 34, the 4-step algorithm for determining whether or not an intervening cause is superseding, which means that it breaks the causal link, or not, which means it doesn't break the causal link. The third and last video, the proximate cause doctrine, is going to end with 2 additional cases that apply Rule 34. It is going to address matters of criminal acts as intervening acts, and it is going to introduce the rescue doctrine. Thank you, and I look forward to seeing you in video 3.